If you are applying for a green card and you file the wrong form on the wrong day, your entire application gets rejected instantly. No review, no warning, no second chance. That is exactly what is about to happen to thousands of people starting September 18th, and if you do not know this one detail, you could lose months of work and thousands of dollars in a single mistake. Stick with me for the next few minutes because I am going to walk you through exactly what is changing, why it is changing, and what you need to do right now to protect your green card case. Before we go further, if you find this helpful, hit that like button and subscribe to the channel, because I cover U.S. immigration updates like this every single week, and you do not want to miss the next one. Now, let's talk about what is actually happening here, because this is bigger than just a form update. This is a real deadline with real consequences. Form I-485 is the official application that most people use to become a permanent resident of the United States, also known as getting your green card. Whether you are applying through your spouse, your employer, a family member, or an investment program like EB-5, this is the form that stands between you and permanent residency. For years, applicants have used the version of this form dated January 20th, 2025, and USCIS has accepted it without much drama. But starting September 18th, 2026, everything changes because USCIS is releasing a brand new edition of Form I-485, and this time, there is no grace period at all. Let me repeat that, because it is the most important part of this entire video. There is no grace period. Normally, when USCIS updates a form, they give applicants weeks or even months to switch over to the new version. This time, they are not doing that. The switch happens instantly, on one exact date, with zero flexibility. So why is USCIS suddenly being this strict about a paperwork update? The answer lies in something called the Public Charge Ground of Inadmissibility Final Rule, which also takes effect on the very same day, September 18, 2026. In simple terms, this rule affects how the government decides whether an applicant is likely to depend on government assistance in the future. USCIS redesigned Form I-485 specifically to match the new questions required under this public charge rule. That is why they cannot allow a transition period, because the old form simply does not ask the right questions anymore under the new law. Here is exactly how the dates work, so pay close attention. If you file your green card application before September 18, 2026, you must use the current form, the one dated January 20, 2025. If you file on or after September 18, 2026, you are required to use the brand new version, dated September 18, 2026. If you accidentally use the old form on or after that date, USCIS will reject your application immediately. And if you try to use the new form too early, before September 18th, that gets rejected too. There is no wiggle room here. The date on your form has to match the date you file, or your case does not even get considered. Imagine spending weeks gathering documents, filling out paperwork, paying the filing fee, only to have your entire application bounced back because you used a form that was one day out of date. That is not a hypothetical. That is happening to real applicants who are not paying attention to this deadline. Now let's talk about what actually changed inside the new form, because it is not just the date on the cover page. The biggest changes are in Part 9 of the form, which deals with public charge-related questions. In the old version, applicants were asked separate questions about receiving cash assistance and about long-term institutionalization at government expense. In the new version, USCIS has combined these into a single, broader question, asking simply whether you have ever received any means-tested public benefit. If your answer is yes, the form now requires much more detail than before. You will need to list the specific benefit you received, the exact dates you received it, the dollar amount involved, and the reason you needed that assistance in the first place. This is a significant change because it puts more responsibility on the applicant to be transparent and specific. On top of that, USCIS has actually removed a lot of the detailed explanatory guidance that used to appear in the form's instructions. That means applicants will need to do more independent research to understand exactly how to answer these public charge questions correctly. This is one of those moments where a small mistake on paper can create a big problem for your immigration case. Let me paint a picture for you so this feels real instead of just legal talk. Picture a woman named Maria, who has been living and working in the United States for years on a valid visa, married to a U.S. citizen, and finally ready to file for her green card. She has been preparing for months, saving money for the filing fees, gathering financial documents, medical records, and letters of support. Her lawyer tells her the paperwork is ready, and she plans to mail everything out during the third week of September. But she does not realize that her filing date falls right on September 19th, one day after the new rule kicks in. She still has the old form sitting in her folder, the one her lawyer originally prepared months earlier. If nobody catches this in time, her entire application, months of preparation, gets sent back untouched. This is not about being unprepared. This is about one small detail slipping through the cracks during a policy transition. And Maria's story is exactly why USCIS released a preview version of the new form and instructions weeks in advance, so applicants and attorneys have time to prepare. If you are currently working with an immigration attorney, this is the perfect moment to ask them directly which edition of Form I-485 they plan to use for your specific filing date. If you are filing on your own, without a lawyer, this becomes even more critical because there is no one double-checking your paperwork before it goes out. Before you submit anything, always check the edition date printed at the bottom of the form. It is usually a small line of text, but it makes all the difference. If that date does not match the rules for your filing date, stop, do not send it, fix it first. Now let's talk about who exactly this affects, because it is not just one category of green card applicants. This impacts family-based green card applicants, people applying through a spouse, parent, or other close relative. It impacts employment-based applicants, people whose green card is tied to a job offer or a specific employer sponsorship. It also impacts investor-based applicants, including those going through the EB-5 investment program, who often file Form I-485 alongside other petitions. Basically, if your path to a green card runs through Form I-485, this deadline applies to you, no matter which category you fall into. For EB-5 investors specifically, there is an additional layer to this because many of them file Form I-485 at the same time as their investment petition, known as concurrent filing. If your paperwork is ready and you are eligible to file before September 18th, doing so lets you use the current, simpler version of the form. If your filing happens to land on or after that date, you will need to prepare for the new public charge questions instead. This does not mean you should rush your filing carelessly just to beat the deadline. A rushed and incomplete application can cause its own problems. But it does mean timing deserves real thought, especially if you are close to being ready and the date works out either way. Let me give you a second example because I want this to feel real for every type of applicant watching, not just family-based cases. Think about a software engineer named David, working in the United States on an employer-sponsored visa, whose company has been sponsoring his green card process for almost 2 years. His employer's legal team finally gets the green light to file Form I-485 in mid-September, and everyone assumes the paperwork is standard and routine. But the HR department, not the immigration attorney, happens to print the form a few weeks early and saves it to a shared company folder. When filing day arrives, someone on the team grabs that saved copy without double-checking the edition date at the bottom of the page. If that copy happens to be the old version and the actual mailing date falls on or after September 18th, the entire petition gets rejected, delaying David's case by months. This is exactly why even well-organized companies and legal teams need to build a specific check into their process just for this one date. It is not about intelligence or effort. It is about one small printed date at the bottom of a government form that most people would never think twice about. Now here is something else worth understanding. USCIS is not trying to make this harder on purpose. They are trying to align the paperwork with a brand new federal rule. Think of it like updating a test to match a new textbook. If the textbook changes, the old test questions simply do not match anymore. That is essentially what happened here. The public charge rule changed the substance of what the government needs to know, so the form had to change with it. Understanding the reason behind the deadline actually makes it easier to remember, because it is not random. It is tied directly to a real policy shift happening on that same day. Let's take a moment to talk about why USCIS is being so strict this time, with zero grace period. In the past, when forms were updated for things like formatting or minor clarifications, a grace period made sense because the substance of the application had not really changed. This time, the form itself is legally tied to a brand new federal rule that takes effect on a specific date. Using the old form after that date would mean applicants are not even being asked the legally required questions under the new public charge standard. That is likely why USCIS decided there simply cannot be any overlap between the two versions. It is strict, but at least it is predictable, because now you know exactly what to expect and exactly when the change happens. The real risk here is not the new rule itself. The real risk is people not knowing about it until it is too late. That is honestly one of the biggest reasons I make videos like this, because immigration law moves fast, and small details like a form addition date rarely make the news, but they can completely derail someone's case. If you know anyone currently preparing a green card application, a friend, a coworker, a family member, this is the moment to send them this video, because this single date could save them from a painful rejection. Now let's go over exactly what you should do to stay protected through this transition. First, figure out your realistic filing timeline and be honest with yourself about whether your documents will actually be ready before or after September 18th. Second, always download the form directly from the official USCIS website close to your filing date, instead of using an old saved copy on your computer. Third, check the edition date at the bottom of every page, not just the first page, because attorneys always verify page by page for a reason. Fourth, if you are working with legal representation, confirm directly with them which version they are preparing. Do not just assume they have already accounted for this change. Fifth, if you are filing electronically, make sure the online system is updated for the September 18th edition before you hit submit. Sixth, keep copies of everything you filed, along with the date it was postmarked or electronically submitted, in case you ever need to prove exactly when your case went in. These steps sound simple, but together, they are the difference between a smooth filing and a frustrating rejection letter weeks later. I also want to be clear about something important. This video is for informational purposes, and immigration cases can get complicated fast, especially with a new public charge rule involved. If your situation involves any past use of public benefits, unusual employment history, or anything that feels complicated, it is worth speaking with a licensed immigration attorney before you file. A short conversation with a professional now could prevent a much bigger headache or even a denial later. Let's zoom out for a second and think about the bigger picture here, because this Form I-485 change is really part of a larger shift in how the government is handling immigration paperwork. We are seeing more precise deadlines, less flexibility, and a stronger expectation that applicants stay informed on their own. That means channels like this one become even more valuable, because staying updated is no longer optional. It is necessary if you want your case to move forward smoothly. So here is my honest advice. Mark September 18th, 2026 on your calendar right now, today, before you forget. If your filing date is close to that line, talk to your attorney this week, not next month, this week. Do not let a form update be the reason your green card journey gets delayed. You have already put in the time, the paperwork, the waiting. Do not let one overlooked detail undo all of that effort. Before you go, I want to ask you for something small but really meaningful for this channel. If this video helped clear things up for you, drop a comment below and let me know your filing timeline. Are you filing before September 18th or after? I read every comment, and honestly, hearing your situations helps me figure out exactly what topics to cover next. And if you know someone who is in the middle of a green card application right now, please share this video with them directly. It could genuinely save their case from getting rejected over a technicality. One more thing before you leave, hit that subscribe button if you have not already, because immigration rules keep changing, and I will keep breaking them down for you in plain, simple language, no confusing legal jargon. Thank you so much for watching all the way to the end. That genuinely means a lot, and I will see you in the next video.